further ado, here we are. Here's the order denying R. Kelly's bail. So basically, there's three judges involved in the appeals judgment or the appeals order. Deborah Ann Livingston, John M. Walker, and Dennis Jacobs. Now, again, so this is the appeal for R. Kelly's bail relief. And of course, R. Kelly is the appellate, and the United States government is the appellee, right? Now, I'm going to try to get through most of this stuff as quickly as possible, and I'm going to try to skip over as much as I possibly can. So I've already read this, and I've highlighted the stuff that I actually want to cover, right? So basically, this order involves several statutes. The first statute is 3142E, and then the same statute actually is going to be 3142I. Now, if you're not familiar with those statutes, we're going to kind of like graze over it here, but I have several videos where I look at R. Kelly's bail release and we look at R. Kelly's bail denial and the previous orders. If you want to get more information on the statutes, you should go back and look at those videos. But let's just go ahead and get into it. So it goes on to say, we apply differential review to a district court's order of detention. It will not reverse except for clear error. Unless on the entire evidence, we are left with the definite and firm conviction that a mistake has been committed. And they give some case law for that, right? A district court is instructed to, hold on a second, let me not go too far. So the first thing I just want to say is that there's different types of reviews, and I've never heard of a differential review. So basically, anytime you go to a higher court and you're trying to appeal the lower court's decision, you can ask that court to use a certain standard of review. Now, differential review, I did do a quick lookup on this, and before reading this order, I had really never heard of differential review. And from my understanding, it's a restrictive review, meaning they're not going above and beyond what's presented to them, right? And they probably didn't even look at the entire case file for the Eastern District of New York. Now, me personally, I probably would have asked for a de novo review. And the reason would probably ask for that is because a de novo review basically means that the higher court is going to take a new look, right? De novo basically will, in Latin, novo means new, right? And I assume that de novo means, taking a new look, right? So I would have asked the court to do a de novo review, which is going to include the court taking a fresh look at everything. And I believe with the de novo review, you allow the possibility of the court making findings that your rights were violated, or there were some due process rights in the actual review. Whereas a differential review, I don't believe it's going to be an exhaustive review, and I don't know how much it's going to be restrictive, right? So I don't think I would have asked for that. But I'm just going to say again, if you don't know me, let me just tell you now, I'm not a lawyer. I'm just some guy on the internet reading legal documents. So take everything I say with a grain of salt. He has lawyers. Those lawyers decided to do what they did. I don't remember them actually asking for any particular standard of the review. I have to go back and look at the actual appeal to see if they requested a standard of review. But again, so he has lawyers. Those lawyers are making the best decisions for him. They know what's going on. They know all the details. They have experience. They have education. They have training. I don't have any of those things. So anyway, moving on. And then it goes on to say that a district court is instructed to order the pretrial detention of a defendant if, after hearing, the judge finds that no condition or combination of conditions will reasonably assure the appearance of the person as required and the safety of any other person and the community, right? And then they give some case law for that. Now, that's actually what's in the statute. So they really just quoted the statute here, 3142E. But again, there's more to this statute. And if you want to know more, basically go to my YouTube page and then look up the videos surrounding R. Kelly's bail release. So they go on. Here, a defendant has been charged with the offense involving minor victims under 2251, 2421, 2422, 2423. I cover all those on my page, on my YouTube channel. A rebuttal permission arises that no conditions can provide the requisite assurance. And then they go on to say the defendant bears limited burden of production, not a burden of persuasion. But I'm sorry, to rebut the presumption by coming forward with the evidence that he does not pose a danger to the community or risk of flight. And then they go on to say once the burden of production is met, the presumption does not disappear entirely, but rather remains a factor to be considered among those weighed by the district court. Even a presumption case, the government retains the ultimate burden of persuasion by clear and convincing evidence that the defendant presents a danger to the community and by the lesser standards of preponderance of evidence that the defendant presents a risk of flight. Right? So I understand this paragraph to mean that in this situation, R. Kelly has a very low bar to basically prove that he should be, or argue. He has a very low bar to argue that he should be released out for bail. The government has a high bar or an extremely high standard to prove that he should be remanded or he should be kept in jail. Moving on. And then it goes on to say, or they go on to say, Kelly also seeks temporary release under 18 USC 3142I. Under that provision, a judicial officer may permit the temporary release of the person in the custody of the United States Marshal or other appropriate persons to the extent that the judicial officer determines such release to be necessary for preparation of the person's defense or for another compelling reason. And then it quotes 183142I. Now, quick history on this. This is kind of funny because after doing the first couple of videos on R. Kelly's bail release, I kind of believed at the time the way his lawyers were presenting his bail that he should have probably taken a different route. And I said to myself, he should be able to go before the judge and say, hey, I'm going to ask for you to release me on bail, but I'm going to be under the custody of some type of authority, right? Either, at the time I didn't really know, who he could be released to, but basically it could have, I was thinking of the sheriffs, the police, or, the FBI. I really didn't know that there was actually a specific clause that would have allowed him to be released out on bail, but under the custody of the U.S. Marshals. I think at first I was thinking maybe the Federal Witness Protection Program, maybe they could modify that, right? But at that time I was just trying to come up with a theory on how he could present an argument to the court. And then I actually saw a Netflix video where they talk about how Jeffrey Epstein was released on bail. And I think in Jeffrey Epstein's situation, he was released to the sheriffs at the time, right? So I made a video on that. You can check that video out. So that caused me to actually make that, another video and said, hey, R. Kelly can ask for something similar. They gave it to Jeffrey Epstein, right? Well, it turns out there is a specific clause that allows him to be released to the custody of the U.S. Marshal. I'm not sure how that program would work, but I can imagine that it could be a situation where the marshals would probably stay in his apartment, or they would do like a shift rotation. And whenever R. Kelly would go out, uh, they would go out with him. And then when I say stay in his apartment, I mean, maybe outside the apartment, or, just to sit and watch over him. To me, that seemed like a realistic option. And to me, that seemed like a condition that would guarantee that he wouldn't do any of these things that they're accusing him of possibly doing, which is victimize people and basically, become a flight risk. There's no if the marshals are your, if they're your escorts, and you get away from the marshals, then you know, basically no jail can hold you. In my personal opinion, right? I mean, R. Kelly's not a crime boss. It's not like he's going to hire somebody to whack the marshals, anything like that. But anyway, I just thought it was interesting that there was actually a possibility for that to happen. But anyway, moving on. We perceive no clear error in the district court's determination that the government has demonstrated by clear and convincing evidence that Kelly presents risk of danger to the community, and by preponderance of evidence that Kelly presents a flight risk, and moreover, that no condition or combination of conditions could assure against those risks. Likewise, the court did not clearly err in determining that Kelly failed to demonstrate a compelling reason for a temporary release. We assume that adequate opportunity for consultation with the counsel will be assured as a matter of trial administration by the judges who will preside over the two trials. And accordingly, we affirm the district court's denial of release for substantially the reasons set forth in its well-reasoned order of May 15th, 2020. Right? So they said a lot in this paragraph. The first thing that they're saying is that they basically agree with the lower court, right? They agree with the lower court, and they're saying there's no condition or combination of conditions that's going to remove the risk that R. Kelly would victimize more people, or that R. Kelly would basically just up and run, right? Now, me personally, I don't believe that he victimized anybody, and I don't believe that he would victimize people when he gets out of prison. And I don't really believe he's a flight risk, right? So this is just what they're saying, right? So they agree with the lower court's decision. And then the other thing that's going on here is they're talking about his right to counsel. Now, this whole thing just seems a little crazy to me, because he's been locked up for over a year. This is actually unlawful for you to keep a person locked up for this amount of time and not give him a trial. And not only have you not given him a trial, but he hasn't gotten a chance to go over the evidence with his lawyers. And he doesn't even know who all the witnesses against him are. These are serious constitutional violations, in my personal opinion. And to make matters worse, he hasn't really gotten a chance to sit down with his lawyers to basically map out a strategy, right? So I guess they're probably going to argue that the pandemic has changed the game a little bit, and it's only because of the pandemic that we have this situation. Maybe that's what they're going to argue. But they're saying, I mean, if there could be any light at the end of this tunnel, they're saying that the trial judge, and actually they're not even saying that, they're saying we assume the trial judge is going to make sure that he gets the opportunity to meet with his counsel. they're making an assumption, and to me, that's not good enough. I think this is the appeals court, and this is why I probably would have asked for a de novo review, because a de novo review probably would have given the appellate court the ability, or maybe tasked them with the duty to making sure that this happens. Um, I would almost, yeah. So this is just really bad, and kind of confusing as to what to do, because, like I said, these are serious constitutional violations. He's been locked up for over a year. He hasn't had a chance to really meet with his counsel. He hasn't seen the evidence, and he hasn't had a chance to get information on the witnesses against him in court, right? So this is very serious constitutional violations. And personally, I believe they should have ordered that he be given a chance to meet with his counsel. I think that should have actually been ordered, but I'm not sure if it's because of the review that they asked for, and I don't even know if they asked for a differential review. Maybe they just did a differential review because they didn't ask for it. I'd have to look at the other R. Kelly appeals bail motion to see what kind of review they asked for. But basically, I believe if he would have asked for a de novo review, they would have had the duty to say, hey, he hasn't seen his lawyers, he hasn't consulted with them. This is a very serious constitutional violation. We need to make sure that he meets with his lawyers immediately. And they probably would have put that in the appeals order, right? But the thing about appeals is they typically don't grant you things that you didn't ask for. However, I believe, and like I said, don't quote me on this. If you're a lawyer and you know better, leave a question or comment below to educate us. But I believe a de novo review would basically give the appeals court the responsibility to look at constitutional violations like this and make an order on that, right? So that's the other thing. And then, finally, they are saying that the lower court did a really good job. You have to listen, or the devil is in the details. You have to pay attention to what they're saying. They go, accordingly, we affirm the district court's denial of release for substantially the same reasons set forth in its weld reason order of May 15th, 2020. Right? So in my opinion, they're saying not only did they agree with the lower court, but they're also saying, in between the lines, right? You read between the words. They're also saying that Judge Ann Donnelly did a good job, right? So you guys, let me know how you feel about that. Leave your questions and comments below, right? So where do we go from here? Now, me personally, me personally, I think the bail, the chances for bail are pretty much over at this point. There's still a slim chance, a very slim chance he could appeal to the Supreme Court. He could do that. And the reason I say it's slim is because he's in a situation where he, in my personal opinion, right? I can't tell you what R. Kelly needs to do. I can only tell you what I would do, right? In this situation, I believe I would have to pick my battles. And it would depend on the resources I have. If I have enough money to hire an army of lawyers, I would hire an army of lawyers, and I would say, hey, lawyer A, you focus on the appeals brief, and then you chase that all the way up to Supreme Court, right? But what's starting to happen is that you're getting different instances of these hearings, and what I mean by that is that you go to court for one thing, and two or three other things pop up involving that one thing you went to court for. Then you go to court for another thing, and then two or three other things pop up. So from my understanding, of how these things work, court cases work. When they want you and they want to get you, they're going to basically kind of keep you trapped into court. And because you're trapped into court, they're constantly filing things in court. And because they're constantly filing things in court, you have to respond to all those little things. And when you respond to what they file, then they're going to respond to what you responded to. And then in addition to that, you're going to want to file things on your own. So you file something on your own that has not necessarily anything to do with what the opposing party has filed. And now the opposing party has to file to that, and then you get a chance to come back and get the final reply to that, right? So these things have a way of just kind of spinning out of control, and you have to have a lot of money to keep this thing going. Now, the government has unlimited resources. They can basically do this all day, every day, and it's not going to be any sweat off their back because they have the resources to do it. They could put 300 people on R. Kelly's case, 300 lawyers. I'm pretty sure they have 300 people, but they could literally put 300 lawyers on R. Kelly's case to try to, just frivolously file things to basically tire him out, right? And when I say frivolously file things, I would hope that the government would do that, but more likely they would file things and they would, make them look bona fide and official, right? So and you guys know there's already been some shenanigans in this case where they actually subpoenaed the financial records regarding R. Kelly's lawyers, if I'm not mistaken, right? So each time something happens in this case, that yet becomes another thing that you have to pay a lawyer to basically handle. So that's why I say R. Kelly has to choose his battles. And if I was in a situation, I would choose to focus on the RICO charge, which is in New York, and I would choose to focus on the conspiracy to defraud the United States. And the reason I would be afraid of those charges is because those are gateway charges. Those are charges that allow them to bring in old garbage, right? For example, in Illinois, and I keep saying this, so you guys probably know I'm a broken record by now, but in Chicago, basically, the conspiracy to defraud the United States is allowing them to drag the 2008 case back. He's already beat that, but they're claiming that he cheated. So they're trying to drag it back. So now he has to deal with that over again. And I actually have a video series going on where I plan to explain why double jeopardy should keep them from using that 2008 case. And I need to finish up that series. I haven't, found time to do it, but I will. And then, of course, there's also the RICO charge. The RICO charge is allowing them to bring in old stuff and cross state lines and get things into New York that probably shouldn't even be there, right? So that's why I say, in my personal opinion, if I was in his shoes, I would focus on those two charges. That's where I would put the bulk of my efforts. And then once, if he loses, I'm not saying that he's going to lose, but if he loses, then he has to also focus on the appeal. So I don't know how much resources he has. I don't know how much money he has. I don't know how many lawyers he has on the team. But at some point, you have to choose your battles. But if he has the money where he has unlimited resources, then for sure he can go ahead and try to take this appeal to Supreme Court to see if he can get bail relief. But I think the government is going to be a little slick with this, because what they're going to do is that they're going to try to speed up this case so that R. Kelly would just be wasting his time trying to take it to Supreme Court, right? Because the case would have already been started then, and then the bail would be, null and void. Um, so I don't know. I just think that the bail is over, and he really needs to focus on beating the case, right? So I don't know. So that's going to be it for this video. Leave your questions and comments below. Please like, share, and subscribe.